Welcome back to Aspire Australia's webinar on understanding Australian visa options for partners. This is part 2 in relation to sponsorship. So in part 1, we looked at the visa criteria for a partner visa, the different strategies and options available, and the evidence. So now we're going to look at what is required of the sponsor for the partner visa. As you know, we're on a mission to provide the correct information to potential visa applicants so that you have the right information and can prepare your application in such a way that it will be not only decision ready, but approval ready. So by the end of this session, you will understand who can and cannot be a sponsor, what are the responsibilities of a sponsor, and the evidence you would need to ensure that the sponsorship application is approval ready. The goal is twofold here. The sponsorship should be approved by the Department of Home Affairs so that the visa application can also be approved. So let's look at the sponsorship criteria. So every partner visa application requires a sponsorship, whether that's through the engaged pathway, the married pathway, or the de facto pathway. So the sponsor must be an Australian permanent resident or citizen or an eligible New Zealand citizen. The sponsor must be at least 18 years of age, unless a parent guardian is acting as sponsor. And importantly, the sponsor must have the capacity to help the visa applicant as required financially and in relation to accommodation for a period of 2 years. So the visa applicant, when he or she obtains the partner visa, will not have access to any social security in Australia. So it is the sponsor's responsibility to ensure that the visa holder has a roof over his or her head and is able to survive in terms of food, clothing, health needs, etc. So the Department of Home Affairs, when assessing this sponsorship criterion, will look at the status of the sponsor. Is the sponsor working? Does he or she have an income? Does the sponsor have any money saved in a fixed term account or elsewhere? Does the sponsor own accommodation or has rented accommodation where the visa applicant can live? There is no minimum threshold in terms of salary or income, but a judgment will be made based on the earning capacity and history of the sponsor. And we'll look later at the evidence you would provide to support your claim to this capacity. And the final requirement for sponsors is that there are no sponsorship limitations applying. And we're going to look at those in detail. So if a sponsorship limitation applies, it means that the sponsor cannot sponsor the visa applicant and the visa applicant therefore cannot lodge his or her visa application. So the first limitation is where the sponsor has previously been sponsored him or herself as a partner. So if the sponsor has been sponsored as a partner, more than 5 years must have passed since the date the sponsor lodged his or her own visa application and the date that the new sponsorship and visa application are being assessed. So it's 5 years from the date the sponsor applied for his or her partner visa to the date that the current visa application is assessed. If we look at a case study to make this clear, so Mary marries John, obtains the offshore partner visas, and they live in Australia, but down the track they divorce. Now Mary enters a new relationship with a UK national, and having married, Mary wants to sponsor Fred to Australia. Mary had originally lodged her visa application in August 2016, and it's now March 2021. So 5 years have not yet passed between the date Mary applied for her visa and now. But Fred and Mary know that a partner visa is likely to take quite some months to be processed by the department, and the 5 years must be ended by the date the department is ready to make a decision on Fred's visa. So that is about 5 months away until the 5 years has passed. Fred and Mary take the gamble that the department won't make a decision within those 5 months and lodge the application in any event. The second sponsorship limitation is where the sponsor was granted a parent visa in the contributory category. And it often happens that because of the high fees involved, Australian citizens who are sponsoring their parent may decide to only sponsor one parent and save some money, and then think that that parent can sponsor his or her partner subsequently. But there must be 5 years from the date that the contributory parent visa was granted to the parent and the date that the new partner visa application is lodged. The third limitation is where the current sponsor has previously sponsored a partner for a partner visa. So the rule is that no more than one previous sponsorship should have occurred, and there should be 5 years between the date of the first application and the second decision. And the only exception is if there are compelling and compassionate circumstances. Now, those circumstances could be many. It could be that the health of the sponsor is in jeopardy and he or she needs the partner to be in Australia. There could be children that are involved, and that could give rise to compelling or compassionate circumstances relevant to the sponsor. Also, if the first partner that the sponsor sponsored had died or had abandoned the sponsor, that could be reason enough for compelling and compassionate circumstances to be invoked and the new sponsorship considered. And I note that if the sponsor sponsored a partner and that partner obtained the visa through family violence, that still counts against the sponsor as one of the two possible sponsorships. So we have a case study here. Again, we've got John sponsoring Mary for her visa. They lived together for a few years, then they divorced. John then married Angela and sponsored her for an onshore partner visa. The relationship broke down because Angela claimed that there was family violence. Sometime later, John now starts living with Frida and wants to sponsor Frida. So it has been more than 5 years since John originally sponsored Mary, but because John has already sponsored Mary and sponsored Angela, he has already had his 2 sponsorships. In this case, however, John and Frida have a child together, and they decide that they will try and claim compelling circumstances. In that, if John is not allowed to sponsor Frida and John can't leave Australia, that the child would either remain with John and then have the loss of the mother, or the child would leave with Frida and John would not have the benefit of having his child with him. There is a 4th limitation that relates to child violence offences. So if the sponsor is sponsoring a partner and the partner has a child who is under 18 years of age, if the sponsor has had any charge or conviction on a child violence offence, then the sponsorship would not be permitted. Now, there are discretions available for compelling circumstances, or if the sentence for the child violence offence was completed more than 5 years ago. And discretions might exist around how long the sponsor has already spent on his sentence. So if he had a sentence of 4 years and has already completed 4.5 years, that may be considered sufficiently compelling circumstances. If the relationship has been ongoing for a very long time, that may be considered compelling. And also if there are children of the relationship. So as well as the visa applicant having a child, if the sponsor and the visa applicant also have a child, that may be considered sufficiently compelling reason to allow the sponsorship to proceed. The final sponsorship limitation also relates to the sponsor having a record, in this case, a significant criminal record. And you can see on the slide the offences that will be captured by this sponsorship limitation. So if the sponsor has been found guilty of any of those offences and has been sentenced to death, imprisonment for life, or imprisonment for 12 months or more in relation to any of those, then the sponsor will not be permitted to sponsor his or her partner. Again, a discretion exists and may be applied if, for example, the relationship has been a long one between the sponsor and the visa applicant, if there are any children of that relationship, and also a discretion could be applied if the sentence or the time spent on the sentence has been quite long. So, for example, if the sentence was for 5 years and the sponsor had already completed 4.5 years of that sentence, that may be considered appropriate for the discretion to be applied because the sentence is almost over. Now, in most cases, there will not be any sponsorship limitations, but of course, it's important to know what they are, just in case in your situation you are captured by one of those limitations. So sponsors must provide evidence to support their sponsorship application. Obviously, evidence of their Australian status will be required, such as birth certificate, passport, permanent residence visa, citizenship certificate, to meet the Australian requirement or New Zealand citizen requirement. Identification must also be provided. Usually that would be a passport or a birth certificate. And as we mentioned earlier, the sponsor must show he or she has capacity to support the visa applicant. So evidence of income by way of pay slips, tax assessment notices, employment contract should be provided. And if the sponsor has any assets, such as a house, then evidence of that should be provided by way of rates notice or title deed. Other assets like a bank statement or share portfolio can be provided to show income and or capacity. And regardless of whether the sponsor has a conviction or not, a police clearance certificate must be provided for each country in which the sponsor has lived for at least 12 months in the past 10 years since turning 16 years of age. So if the sponsor has only ever lived in Australia, that would be from Australia. If they have lived in other countries, then if the sponsor had lived for at least 12 months cumulatively in that country during the past 10 years, then a police certificate would be required from that country as well. And if the sponsor has any convictions, even if they're not convictions that would give rise to a limitation, you should consider whether you should provide character references to ensure that the sponsorship is not going to be refused on the basis of character. And of course, if there were a limitation that applied on the basis of child violence offences or significant criminal record, then much more detailed evidence would be required of the offences, the sentencing reports, any paroles, or other information, plus plenty of character evidence, references and the like. So whilst the sponsor does not need to provide a plethora of documentation, these items are important: the identification, Australian status, and capacity to support the visa applicant. And again, there are no prescriptions in regards to capacity, so it's an individual assessment based on the circumstances of each case. Our advice, as always, is to get started early. So don't leave things to the last minute, and ensure that you get advice so that you know if there are any factors that are going to affect your sponsorship application. Make a decision on how you're going to proceed. For example, we saw the case studies with Mary and John. So some of the decisions may be, do we apply now or do we wait? And then commit to your plan, but some flexibility may also be required. And because the process can take a very long time, stay motivated and know that you've put in the best application possible. And in that regard, whilst you will supply evidence at the time of lodging the sponsorship, it is always a good idea to update that every 4 to 6 months. So provide updated pay slips, bank statements, or any other relevant documentation. As always, if you need help in preparing your application, we're here to be your migration superhero. We have a process that we follow that ensures that there are no gaps and your application is put together in a way that will be efficiently processed by the department and approved. And why choose us? This is who we are. We love rules. We think they show us the pathway to possible. We know where the boundaries are, where we can push, how far we can push. We always want to get it right, and we invite you to have us in your corner. Feel free to get in touch with us by email or phone. Check out the resources we have on our website, and I look forward to speaking to you soon.